Bench, you can do that right there. All right, got everybody here?
Yes, Your Honor.
All right, Ms. Giles, good morning. You in here yet?
Yes.
Can you hear me?
Yes, I can. Yes, sir.
All right, Mr. Giles?
Yes, sir.
Mr. Stafford?
Morning, Your Honor.
All right, got everybody here, you can hear. All right. We'll get started. I will call for a hearing, calls number 324-673-59519, styled in the manner of the marriage of Jillian Giles and Thomas Giles, and in the interest of Hunter Giles, a child. Present today is the petitioner, Jillian Giles, and her attorney, Rick Mitchell. The respondent, Thomas Giles, is also present, along with his attorney, Gene Salos. I'm going to ask that everyone who expects to testify in the Giles case to please raise your right hands. Do you all swear or affirm the testimony that you'll give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, and the purpose of this hearing is a request for a de novo hearing filed by Mr. Salos on behalf of Mr. Giles. So, Mr. Stafford, I'm going to put you back in the waiting room, and then we'll call you back in, hopefully in not too distant future, to get you back in and let you provide your testimony if necessary, okay?
Okay.
So Jennifer, if you can move Mr. Giles back, Mr. Stafford back out to the waiting room.
Yes, sir. Okay.
All right, and Mr. Salos, it's my understanding that you had some argument that you wish to make prior to our commencing with the testimony in this case. Is that correct?
Yes, Your Honor. It is, and if it pleases the court, I'm ready to proceed.
Then please proceed.
All right, and Judge, I'm going to ask the court to take judicial notice of two documents. One is the corrected final decree of divorce, and the other one is the protective order that was signed by this court on March 9th of 2020.
I would do so.
Thank you. So briefly, Judge, there is a kind of an odd timeline in this case. And just for the record, the parties entered into a mediated settlement agreement earlier in 2020. There was an alleged incident that occurred between the parties while they were still cohabitating after the MSA, but before the final decree was entered. As a result of that, a agreed protective order was signed by the parties with the finding of that there was no family violence. And then because of the virus, there was another issues. There was a delay in the entry of the decree that matched the MSA. That was later done this summer, and a decree was entered. Immediately thereafter, Ms. Giles, through her attorney, filed a modification and temporary restraining order because the terms of the essentially using the protective order and the alleged facts that occurred on that incident as a basis to modify the decree. And that was heard by Judge Polis, and we have filed a de novo from her ruling. The basis of this modification, Your Honor, is that family violence happened, and that it happened by Mr. Giles against Ms. Giles. And our first legal argument, Judge, is that Ms. Giles has already judicially admitted that that didn't happen. If the court refers to the protective order that was signed by the parties in the court, it's specific, all findings of family violence were stricken and initialed off on. So she has admitted already in a prior proceeding that this is what happened, that there was no family violence, because if it had, she would not have struck through those terms and initialed them. It's also judicial estoppel, Your Honor. In other words, it's an inconsistent statement made in a prior proceeding. And now she's trying to say, no, that family violence really did happen. Forget what I agreed to on the protective order. Family violence happened. And so therefore, this needs to be modified. Those inconsistent positions she's taking are barred under Texas law. I would cite the court generally to Texas Supreme Court case called Ferguson versus Building Materials Corporation of America, which is found at 295 Southwest 3rd, 642 from 2009. And a quote from that case is that judicial estoppel precludes a party who successfully maintains a position in one proceeding from afterwards adopting a clearly inconsistent position in another proceeding. So in other words, she's locked in to her admissions and the prior orders of this court when she said there was no family violence, and she can't use the same facts, the same series of events now, take an inconsistent position as a basis to modify the decree that was entered by the court because of the timeline of events. So our first argument is, Judge, that there shouldn't be a modification on the basis of these events at all, because she's already admitted that the family violence didn't happen, and now she's saying something different. Our second argument today, Judge, is going to be that this modification was filed obviously less than 1 year before or after the entry of the decree. And it was also, by the way, within 1 year of the MSA, for whatever that's worth. And so there's a higher standard, obviously, under the family code. She's got to show that basically there's physical endangerment to this child, Hunter Giles, or that there's some kind of harm to his emotional development that is occurring that justifies the modification of the terms of conservatorship, possession, and access. And the facts are going to show that that didn't happen. In fact, immediately after the entry of the protective order, Ms. Giles was the one who initiated contact, supposedly, I guess, in violation of the protective order, initiating contact with Mr. Giles, giving him unsupervised access to the child repeatedly. In other words, acting in manners that are inconsistent with both the terms of the protective order and inconsistent with her allegation that there's some sort of endangerment to the child or that there's some harm to the child's emotional development. And so her conduct after the protective order basically negates its value, and it negates her argument that the possession and access and conservatorship should be modified on the basis of the disputed events that previously happened. Our third argument, Judge, is that the protective order contains specific agreements about possession and access. And so I'm going to refer the court, I don't know if the court has the protective order in front of it, but on page 4 of the protective order that again was agreed by the parties, initialed, signed by the court, it specifically says on the bottom of page 4 that respondent Thomas Brandon Giles is granted possession of and access to Hunter Giles in any manner contained within any order under this cause number, which is, it cites the case number. Why is that important? Well, in other words, at the time of the entry of the protective order, the parties specifically contemplated what Mr. Giles' possession would be as a result of the agreed protective order without any family violence. Okay. In other words, and what was that possession schedule? Well, it was what was contained in the MSA, and later it was what was contained in the decree, and then the corrected decree as entered in October. What I'm getting at is they already dealt with all of the possession issues that arose out of the disputed event that gave rise to the protective order. In other words, they already said, we're agreeing to this, and we know that we're saying specifically, this is what we're doing about the terms of possession. Well, from the time of the protective order until the entry of the corrected decree, there is no other allegation by Ms. Giles that something new between those times happened. So in other words, she's bootstrapping the events of the alleged incident, which was in, I believe, February or March of this year after the MSA, as a basis to change possession when she already agreed in the protective order that the possession would be what the parties had already agreed to. So we're asking that again, under judicial estoppel and frankly, res judicata, because it's contained in the protective order, that there's no basis to modify the possession when this was already addressed. And so for those legal reasons, we're asking that the court simply dismiss the modification. We have no counter pleadings on modification for possession and access on file. We're simply asking that the mod be dismissed entirely and that the parties be bound by the terms as contained in the corrected final decree.
Anything else, Mr. Salas?
Not on my legal argument, Your Honor, no.
Thank you. Mr. Mitchell, do you have a response?
Yes. So first of all, the DENOVO only lists, let me turn your volume all the way down. The DENOVO only lists that we're going to be talking about the possession schedule today, and not the motion to dismiss. And so I'd ask the court not to consider any of these arguments because I didn't have notice that we're going to be talking about these things. But regardless, is your volume on? Is it muted?
It's off.
Okay, sorry, I'm getting some feedback. Are you guys getting echo?
Yes, we hear it. All right, is that-
Yeah, turn it yourself.
It's off. It's off.
all right.
Perhaps Ms. Giles should be muted.
Yeah, if you'll mute yourself, Ms. Giles, I think that will help possibly.
Is it muted? Oh, it's better now. Okay, good. All right. Again, so this is not part of the DENOVO. He's past 30 days, so I don't know that, if it's not set today, that he can bring up these arguments again. But if the court does want to consider it, we're talking about two separate issues. The part that was stricken in the protective order was a provision of standard protective orders that was an agreement so that Mr. Giles could keep his firearms because it was important to him. Let's see here. I don't think, again, I don't have the case that he's talking about, so I would have appreciated some notice of this so I could look through it to see if there's anything distinguishing about it. But I don't believe that striking a standard provision for protective order means that she can no longer talk about some facts that happened that night. More than he assaulted his wife in front of their child, not only in front of their child, while she was holding the child. That's part of the facts that precipitated this. In addition, he's living in a boat like he wasn't supposed to. So there's more facts that came out last time than just a night of family violence. He's talking about the end. As far as the order, talking about possession going forward, concurrently with the protective order, there was a TRO that was entered to take care of this. We knew the protective order allowed possession as pursuant to any order that's out there. And the same time the EPO was done, there was a TRO that was done. And then that TRO turned into an additional emergency order, I believe. I don't have the document here in front of me that governed until we got the decree entered. So from the time of the protective order forward, there's been an order that limited his access. There was never any period where there was this blanket order that put him back to a 50-50 since we got the protective order entered. Again, the biggest thing that this is not part of the DENOVO. The DENOVO is what the possession schedule is going to be like, not my motion to deny relief. So I just would, appreciate a chance to see this case and read through it, and all these all these arguments he's making now were not part of what was supposed to be set this morning.
And Judge, I have no problem with, if the court wants to set deadlines for us to brief this issue, if the court wants further, information on that after the hearing, I'm fine with that. That might be a solution to that issue.
We're outside of the time for a DENOVO, Your Honor. I mean, he needs to bring this up within 3 days of the last hearing, not 45 days later. I mean,
Judge, this relates exactly to possession and access.
I think it's a legitimate argument. I do think that there is possibly some restrictions on actually being able to use family violence. But I do think that Ms. Giles should be able to go forward on any allegations she has as to why Mr. Giles should not have the possession schedule he had before. And so I think some of Mr. Salo's arguments are well taken in that likely the protective order should not have been done in that way. But I'm going to allow the some testimony on this case and hear Ms. Giles' reasons why Mr. Giles' visitation should be modified and then allow Mr. Giles to be able to respond accordingly. And so I'm going to deny your motion to dismiss at this time, Mr. Salos.
Yes, Your Honor. Then, if I may, I'd like to go ahead and call Mr. Stafford.
All right. Jennifer, you want to let him in?
Yes, sir.
Stafford?
Yes, Your Honor.
All right. Let me remind you that you are still under oath. Do you understand that?
Yes, Your Honor.
All right. And so, Mr. Salos, you may proceed.
Please state your name.
Justin Stafford.
And in what way are you connected to this case?
I've seen Brandon Giles professionally as a mental health counselor.
And can you tell the court and counsel briefly what your educational and licensure background is?
I have a Master's of Arts in Mental Health Counseling. I'm an LPC intern under the supervision of Dr. Marion Dumond, LPCS.
And how long have you been LPC intern?
Since October 31st of 2018, I believe.
All right. And when did you first come into contact with Mr. Giles?
I believe our first session was 11/1, so November 1st of 2019.
And approximately how many sessions have you had with Mr. Giles?
I think about 27.
All right. And how often were you seeing him at the peak of those sessions?
We usually see each other once a week, and just depending on scheduling, but typically once a week is what we would try to do.
And what was the purpose of him initiating counseling with you?
Initially, I believe he was asked to come in by his wife at the time, and we were working on some of his past trauma.
His past trauma, you said?
Yes.
Okay. And as it relates to that past trauma, well, let me rephrase. Did the purpose of your treatment of him change at any point during the course of these 20 to 30 sessions?
We worked mostly on trauma, and then we moved somewhat into working on coping with the divorce and missing his son.
All right. And was that a recurrent topic and theme of your counseling after the parties stopped living together?
Yes, it was.
And would you say that was his primary concern, was his access to Hunter?
Yes, it was.
All right. Now, in the course of seeing him these 20 to 30 sessions, did you have a working diagnosis of Mr. Giles?
I did not officially diagnose him at all. He, I believe, would probably fall under PTSD diagnosis. But we don't use insurance, so I've never found it a need to diagnose. I just treat what I'm seeing.
Okay. And if you were to give him a PTSD diagnosis, would that be based on current events or something from his past?
It would be past.
Okay. From his military service specifically?
Yes, in childhood, yes.
All right. Do you believe in your sessions that Mr. Giles was forthright and honest with you?
I do believe that, yes.
And was he receptive to your guidance and suggestions on how he might cope with his life situations?
I believe so.
Did he manifest at any time in session any aggressive intention towards Ms. Giles or the child?
No.
Did you ever have cause to reach out as a mandatory reporter to the police or any other authorities about his anger or demeanor or threats?
No, I did not.
Sitting here, when was the last time you saw him?
He came in, I believe, the 8th to sign a release of information.
And did you have a session at that time, or was it just for the paperwork?
No, it was just for the paperwork.
When's the last time you had a session with him?
August 18th.
All right. And so from that point forward, I mean, do you have any concerns about him being in the presence of Hunter Giles?
No, I
Objection,
did not.
foundation, Your Honor, he wasn't ordered to give any opinions on access.
I'll sustain the objection unless there's a more of a predicate made, Mr.
Okay. Did anything come up in session that would give you concern that he should have some sort of restricted access to the child?
Nothing that I can recall at all.
All right. Did he evince any reckless or thoughtless behavior with respect to the child?
No, we did not.
And sitting here today, do you have any plans on seeing Mr. Giles in the future?
If he comes back, yes.
Okay. But as for right now, is anything scheduled, or is that on your recommendation?
Nothing is scheduled right now. He had improved and was doing better, and we decided to stop work for a little while to see how things went.
All right. And sitting here today, do you maintain that position?
I do.
All right. I'll pass the witness.
Mr. Mitchell?
Yes. Mr. Stafford, so what past trauma did he discuss with you?
Specifically,
Yes.
okay. During his time in service, he witnessed the Cole being attacked during a terrorist attack in Yemen.
Any others?
His father was, I would say, firm and possibly abusive, but I look at it contextually given the time, honestly, but that's something we've looked at as well.
Did he disclose any sort of mental health history with you?
None, no.
Did he disclose whether there are any past hospitalizations or anything like that?
I do not believe so.
If there had been some, would that potentially change the progress of his therapy?
Objection calls for speculation.
Overruled. You may respond, Mr. Stafford.
Thank you, Your Honor. Do I think it would change? Can you say it again?
So if he had disclosed that there had been hospitalization or treatment for certain mental illness as an adolescent or young adult, would that have changed part of your prognosis and part of the path your therapy went?
As I stated before, I usually go with what's in front of me, and I see how he is currently more than the past. So I would take it into account, but I wouldn't necessarily change my path now.
So as his counselor, you're sort of dependent on what he provides, correct?
Correct.
Okay. And was it a fair statement that a full or honest disclosure about past events are important? Is that fair to say?
I would say if you want to get work done, yes, you need to be honest.
Did Mr. Giles disclose to you any of his past charges for domestic violence?
Not that I can recall, no.
So if he had disclosed to you that there were 2 or 3 more issues within the last 10 years before this instance, that might have changed the path of the therapy, correct?
Judge, I'm going to object to relevance. These incidents were specifically known to Ms. Giles before she even married him. So I think it's irrelevant.
Your Honor, she's not testifying right now, and I'm just He's saying that Mr. Giles is great and doesn't need therapy. And I'm just trying to show that if he had gotten the full picture, that therapy may have been a little different.
Overruled.
You can answer, sir.
I would have addressed that. Yes, absolutely.
Did you guys address or discuss any sort of anger management issues?
I do with pretty much everyone that comes in, because I think that's something we all deal with, including all of us. So
Okay. So you haven't seen him around 4 months at this point, correct?
correct.
Okay. All right. No further questions, Your Honor.
Mr. Salas, any other questions, Mr. Stafford?
No, Your Honor, I'd ask that he be released.
Do you have any objections, Mr. Mitchell?
No, Your Honor.
Mr. Stafford, you're excused. Thank you very much. You can log off now if you'd like.
Thank you.
Thank you.
Judge, I'll call Brandon Giles.
All right. Mr. Giles, well, first of all, would you state your name, please?
You're muted, sir.
I'm sorry, yeah, unmute yourself if you would, please, sir.
There we go. Can you hear me now?
Now we can hear you. Will you state your name, please?
Thomas Brandon Giles.
All right, I want you to listen carefully to the warning I'm about to read you. As I understand, there may be some questions of you that may involve some criminal issues. So I want you to listen carefully. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You may have the right to hire an attorney. If you cannot afford an attorney, an attorney will be appointed for you. Do you understand your rights?
Yes, I do, Your Honor.
And do you wish to waive those rights, or do you wish to exercise your Fifth Amendment privilege not to testify regarding any of the issues that those rights may cover?
Can I ask Gene? What am I?
If y'all,
Brandon,
just a moment. Mr.
Brandon,
Giles, would you like to talk to him privately?
no, Your Honor, we've already discussed this. So Brandon, if it's your intention to testify today, then your answer is you want to waive your rights.
Okay, I will waive my right, Your Honor.
And you did fully and completely understand your rights, correct?
Yes, I do, Your Honor.
And understanding those rights, you're knowingly waiving your right to remain silent. Is that right?
Yes, I do, Your Honor.
All right. Thank you. You may proceed, Mr. Salas.
Thank you, Judge. Mr. Giles, please state your full name.
Thomas Brandon Giles.
And you're the father of Hunter and the ex-husband of Jillian, is that correct?
That's correct, sir.
All right. Now, we have provided to the court a summary of your requested relief. Is that correct?
Yes, Your Honor. Yes, sir.
And are you asking the court that the temporary orders entered by Judge Polis be vacated and that the request for modification filed by Jillian be denied?
Yes.
I'll offer exhibit, I believe it's R1. Yeah, R1, Judge.
Do you have any objections to the admission of response exhibit 1, Mr. Mitchell, as a summary?
As a summary, Your Honor.
Response exhibit 1 is admitted as a summary.
All right. Now, Mr. Giles, at the time that you mediated this case, what area of employment were you in?
At the time we mediated the case, I had been a ship captain, but at the time of the mediation, me and Jill had started our own company, and we were trying to get that going, but she had backed out of that.
All right. So, but prior to the mediation, you had been a captain at sea. Is that correct?
Correct.
And under the terms of the mediation and the corrected decree, it was specifically contemplated what might happen if you no longer were at sea. Is that correct?
Correct.
And Judge, I'll ask the court, I believe the court already took judicial notice of the corrected decree.
I have done so. There's some interference here somewhere, Mr. Salas, I think on your end possibly.
Okay, I will turn off my phone.
Is, yeah, Mr. Giles is not in the room with you, is he?
No, he's not.
Okay. Yeah, if you, I don't know, there's some interference there. So you have your phone off and everything?
I just turned my phone off, Judge.
Okay, let's keep trying then. It's not terrible.
All right. So would you agree with me, Mr. Giles, that the MSA and the decree had one set of possession and support if you were at sea, and a different set of possession and support if you were not?
Yes,
And that was specifically negotiated in the MSA and incorporated into the decree, right?
yes.
And when was the last time you worked at sea?
September of 2019.
And how are you presently employed?
I'm working at a marina, a boat repair shop.
At which one?
It's called the Inboard Shop at Lynn Creek Marina,
And on what lake is that?
Joe Pool Lake.
And can you tell the court why you didn't go back to sea?
There's only one reason, it's to see my son. Me and Jill made that decision before the MSA that I was going to stay home to raise him.
Now, the pay is different working at home versus being at sea, isn't it?
Substantially.
And if you were at sea, how often would you be home, for example?
My normal schedule was 28 and 14, so I would work 28 days offshore, then I'd be home for 14, which ended up being about 12 days at home by the time I got done traveling.
And is that the kind of dad you wanted to be?
Absolutely not. No.
Okay. Now, I'm going to direct your attention to what's been marked as Exhibit R3. That's the timeline with Hunter. Okay. Did you prepare that document, sir?
I believe so. Should I be able to see that?
Sure. It's the summary of the events of this summer. Do you recall drafting that?
Oh, they're making it, yes.
Okay. And do you adopt all the facts that are contained in that document? In other words,
Yes.
That's what happened, right?
Yes.
All right. Judge, just for reference, I'm going to ask that R3 be admitted of the summary of my client's testimony as to those events, and I'll go over that in a little bit.
Mr. Mitchell, do you have any objection to admission of response Exhibit 3 as a summary?
Let's see. Let me look. Let me skim through it again real quick.
And Rick, it's the same one we used at the last hearing.
Okay. Yeah, no objection as a summary.
All right, response Exhibit 3 is admitted as a summary.
Thank you, Judge. Now, Mr. Giles, I'm going to go back to the events of the night that led to the entry of the protective order. Are you familiar with those events?
I am.
All right. So I'm going to ask, well, first of all, please understand that once I open the door to this and I ask you questions about it, that Mr. Mitchell has the right to cross-examine you and that you've waived your right to testify or to invoke the privilege, rather. Okay. Do you understand that?
I do.
Okay. Now, on the, first of all,
Gene, can I make reference here to my other with the bring up the issue that I have with the criminal case and her sister?
No, sir.
yes,
Bring that up.
Just a moment. Sir. Just a moment. Sir, what I want you to do, please, would be just to be responsive to the questions. And Mr. Salos and or Mr. Mitchell will ask all the questions that they think need to be
Yes,
asked.
Your Honor. Yes, Your Honor.
Thank you. Go ahead, please, Mr. Salos.
okay. So on the day in question, what's the day we're talking about? When did this happen?
It's in February. I believe it was the 17th.
All
or
right.
18th.
And Where were y'all living at that time?
At that point in time, we'd already started doing we practiced the possession schedule, like the 3 days on, 4 days off. So I was living with Hunter with my parents on my days, and then we were staying at her house on the other days that she was supposed to have him.
And so was it expressly contemplated in the mediated settlement agreement that you guys would be cohabitating after the MSA for a certain period of time?
Yes, until March 1st.
And what was the purpose of that delay of you moving out after the MSA?
So I could find a place to stay and all that.
Okay. And so on February 17th or 18th, you had a right to be at the home. Is that right?
Correct.
What's the address of the home?
6605 Sunny Hill.
All right. Now, did you have a chance to review Jillian's allegations as contained in the application for the protective order?
Yes, I did.
Are they true?
No, they're not.
Was there a verbal conflict between you and Jillian that night?
Yes, there was.
All right. Was there unwanted physical contact between either one of you that night?
Yes, there was.
Okay, I'd like you to describe the unwanted physical contact either by you or by her.
Would you like me to start from the beginning?
Yes, but let me try it a different way. What time of day did things become heated or unpleasant? When did
11 o'clock at night.
Okay.
Sorry, sir, what was your answer? I'm sorry, I couldn't hear your answer. Could you repeat that?
I'm sorry, which answer?
What time did it start?
Oh, at approximately 11 p.m. in the evening.
And what was the precipitating event or conversation?
She'd asked me to come over that night to discuss love. She just typed it in a text message, and I got over there and we were discussing like working things out, and the love thing was something that had been taught in Hunter's school, one of the morning coffee meetings. So I'd gone, that's what she wanted to know about, and we were discussing that.
Okay, just back up real quick. Okay, no, hold on. This is not like a narrative, so I need you to just kind of answer the question, and then I'll ask you another one, okay?
Okay, thought it was.
So she asked you to have that conversation, is that correct?
Correct.
And did you take that to mean that it was about reconciling, even though you guys had just done an MSA?
Objection leading.
Well, okay, I'll rephrase. What was your understanding of the purpose of the conversation?
Whether it was reconciled or not, it was we were just going to talk and have a good conversation about our relationship. That was my record.
Okay, and you were willing to have that conversation, apparently, right?
Yes.
Okay. And so when you got there at 11 o'clock, what happened at 11 o'clock that caused the conversation to turn for the worse?
I had made a comment to her about child support, and she called me. I told her that with the MSA the way it was, I was not going back out to sea. She assumed that I was, and I told her I was not going to go back out to sea. And at that point in time, the conversation was heated, and I told her that she was expecting child support, and I told her that I wasn't going to be paying her child support because if I stay home to raise Hunter, I'm not going to make as much money as I was. And
so that was
okay, that's what started, and she got really upset about it.
I'm sorry, sir, I didn't hear the last part of your answer.
I interrupted. I'm sorry.
I said that's what the conversation started with, and she got very upset about it.
Thank you.
Now, to be clear, you staying home was expressly contemplated in the MSA, right?
Yes.
And it was also expressly stated in the MSA that you staying home would be a material and substantial change to justify a change in the child support, correct?
Correct.
So what happened next after that heated argument about you not going back out to sea?
We were in the master bedroom, which when I was staying there, I was staying in the master bedroom and she was staying in the guest bedroom. And I'd asked her to leave to go back to the guest bedroom, and she refused, and she told me that it was her house and I need to get out. I need to leave.
Okay. Now, just by way of background, were you and Ms. Giles physically intimate with each other after the execution of the MSA?
Yes.
So you mentioned earlier that you guys were contemplating reconciliation. Is that one of the things that made that enter your mind, was that you guys were still intimate even after the MSA?
Yes.
All right. So she asked you to leave, then what?
I picked up her laptop off the bed and started to take it to the other bedroom, and she chunked a shoe at me.
Okay. Why did you take the laptop?
I was trying to get her to go to her bedroom because we were done talking. It was getting out of hand, and I tried to get her to leave.
Okay. After she threw the shoe at you, then what?
Then I threatened to call the cops.
And what did she
threaten that? Excuse me.
What did she say?
As soon as I threatened to call the cops, she ran towards me. I was already out towards the hallway, and she ran after me to grab my phone from me. And she couldn't actually get it away from me, and I just pulled it back. And then she stopped chasing me, and she went to go get her phone. And she said, "It doesn't matter. I'll call the cops." And she says, "Who do you think they're going to believe?"
All right. And did she in fact call the police?
No, she did not.
All right. Now, what happened then?
I took her phone from her
Why?
because she was threatening to call the police when there was not an emergency, and she was doing it.
Now, I'm going to jump out of this timeline briefly. You have entered a diversion program for any criminal charges related to it. Is that correct?
Yes, I have.
I'm sorry, Mr. Salos.
Have you entered a diversion program for the criminal charges that arose out of this event?
Yes, I have.
And do you know the name of the program?
Veterans Court.
All right. And as far as you know, are you in compliance sitting here today with the terms of that diversion program?
Yes, I am.
And does that diversion program encompass all three of the charges that Ms. Giles caused to be filed against you?
Yes, I do.
Okay. So going back to that evening then, what happened after you took her phone?
She tried to get it back.
All right. Did she eventually get it back?
Yes, she did.
How long did you deny her her phone?
I probably had the phone for an hour or maybe an hour and a half.
All right. And so is it your testimony then that sometime in the 1 to 2 a.m. time frame she got the phone back?
I would guess so. I don't recall looking at the clock, but it was probably, I would guess that would be the time.
Okay. Was there any unwanted touching by you of her that evening?
Yes, when she was trying to get the phone back from me, somewhat slapping and I guess you could say clawing at me, trying to get the phone back, I lay down on top of her to get her to stop.
Okay. And how long were you on top of her?
Not very long at all, because Hunter started crying in his bedroom.
I was just going to get to that. So where was Hunter during all this?
He was in his bedroom.
All right. And how far away is that from the room where this occurs?
30 feet.
Okay. So prior to that time, was Hunter in the picture at all?
Not at all, no.
So did Hunter observe you keeping the phone from his mother?
Not at that time, no.
Did he at all that night?
Possibly.
Okay. Did Hunter observe you on top of her that night?
No.
Okay. So was there any unwanted touching that she committed against you that evening?
Yes. When she was trying to get the phone back, she was literally clawing at me and slapping at me, trying to get the phone back.
Okay. Now, was Ms. Giles aware of your history as far as prior criminal charges?
Yes.
And had you guys discussed that prior to your getting married?
Yes, we had.
How, if at all, did that relate to your desire to, well, so just to be clear, did you, after you got up from her, was there any other unwanted touching?
I'm sorry.
Later on, there was, yes.
I'm sorry. I didn't hear all of your answers. This is very difficult to take down with the echoes.
There's lots of interference here with you, Mr. Salas, and with you, Mr. Giles. I'm not sure exactly what the problem is.
Okay, Mr. Giles, do you have any devices on besides your computer?
No, I did not.
Okay, can you mute yourself for a moment, please? Are you still hearing echoes, Your Honor?
No, that was fine there.
Yeah.
Okay, so Mr. Giles, can you unmute yourself?
Did you just a moment? Were you okay there, Jennifer?
Yes, sir.
That is better when y'all are both there together. It's really echoey and it's hard to understand sometimes.
Yeah, and we're not in the same location. So, Mr. Giles, can you unmute, please?
Yes.
Okay, so, yeah, there's some other device on your end that's causing interference. Do you have anything else on?
My phone is on mute.
Oh, turn your phone off if you would, please, sir.
I'm hotspotting through my phone for this.
Uh,
All right. All right.
Let me turn the volume on everything down and all that.
Yeah, I have a feeling that's the problem, but I guess we can only do the best we can. But it's pretty difficult for Jennifer. It's pretty difficult for me. But
Your Honor, let me take my phone and put it on the other side of the room and see if that helps. Get it away from me so maybe it won't echo.
get as far away as you can, if you would.
I'm sorry.
No, I totally agree. It's hard. I know you're having problems with it.
Okay, is that any better?
Yeah, so far it sounds a little better.
Actually put it outside, so
Oh yeah, that's much better right now.
great.
Let's
Sorry
try
about that.
Okay. So, what time was it approximately when she got the phone back?
2 o'clock maybe in the morning.
All right. Were there any other?
You're now echoing.
And you're echoing also, Judge.
I'm echoing too.
I've read an article before that sometimes the YouTube causes an echo. Maybe turn it off, turn it back on.
Well, it's turned off.
May not help, but